next case is ProAmerica Real Estate LLC versus Copley Tire and Auto Repair LLC. And please take a moment to get yourself ready. But as you're doing that, each part of a 15-minute argument. Counsel, do you know how long you'd like to reserve for rebuttal?
Yes, Your Honor. I'd like to reserve 4 minutes for rebuttal.
Okay. I will be keeping that time up here, and you'll be able to see it up there. I guess that's to your left, if I'm thinking correctly.
Thank you.
And you're the top circle. So look at if you look at that, when it gets down to 4 minutes left, at the end of your initial time.
Thank you.
I won't do anything with that bottom rebuttal time, so just ignore that. And then, counsel, you'll have that middle time when you come up.
Thank you.
I'll try to let you know there's about a minute left, just so you're aware of that in your initial time. If you want to talk after that, you can, just come off your rebuttal time.
Thank you, Your Honor.
The arguments are being recorded, so when you come up to make your presentation, number one, please introduce yourself for the record. We're recording you both visually and audibly, however you say that. But we need you back there at the podium so we can see you the whole time and hear you. If you would stay there, we would appreciate that. I don't know that it particularly applies to this case, but if you would have a minor, child, or a victim, please refer to them by initials or some other term. Again, I don't think it really applies in a particular case today. With that, we've read your brief and ready to proceed whenever you are.
Thank you. May it please the court, I am Attorney Renee Roy Spencer here on behalf of the defendant appellant, Copley Tire and Auto Repair LLC, as a result of a judgment issued against it and affirmed against it by the Summit County Court of Common Pleas. The appellant has 5 assignments of error before the court, as indicated within its brief. The first is that the trial court erred and violated the defendant's due process rights when it relied on evidence not presented at trial. The trial court erred when it found that defendant's objections were general and not specific. The trial court erred in finding that the plaintiff was owed back rents when the plaintiff acted in bad faith. And fourth, the trial court erred in finding that the plaintiff substantiated its damages for trash removal and rat extermination. And fifth, the trial court erred in finding that the plaintiff was owed back rents and other damages when it came to court with unclean hands. For the sake of time, the appellant will reserve or focus its arguments this afternoon on its assignment of error number 1. Essentially, appellant is asserting that the trial court's order is fundamentally erroneous, as the judgment was not based on competent and credible evidence presented by the plaintiff, and as a result, the order violates defendant's due process rights. To start, the plaintiff had a burden. The plaintiff had a burden to establish by a preponderance of the evidence that it was owed back rents in this matter and for the time period that the rent was to accrue from. The significance, or to determine back rents, that would mean that the plaintiff had the obligation to establish when it provided the defendant appellant with a key to the building. The only evidence presented by the plaintiff at trial was its statement on page 43 of the transcripts, where it indicated that it provided the defendant's attorney with a key. There was no other testimony by the plaintiff, nor was it developed by plaintiff's counsel. This statement alone does not constitute competent and credible evidence for the trial court to have found or determined that the defendant owed back rents beginning or starting with March 2022.
Now, I think you've acknowledged that you're asserting this is a plain error because this issue was not raised below. Is that correct?
That's correct, Your Honor.
There was a affidavit attached to the brief, according to the argument below, regarding more facts and evidence regarding this particular question when the key was exchanged.
Yes, Your Honor.
Was there any objection made to that below when it was submitted with the brief?
There was no objection to this affidavit when it was filed. However, the defendant's counsel did indicate within its brief, its post-trial brief, that the plaintiff did not establish its burden at trial. And this affidavit that was submitted, it was submitted after the close of evidence. The trial court did not ask the plaintiff or the parties to establish a date when the key was returned. Nevertheless, the plaintiff took the opportunity when it submitted its trial brief to establish what it should have established at trial, given that the text messages were dated February 2022 and the trial was in September of 2023.
At trial, did the magistrate indicate to the parties that there's a question about when this key was exchanged, and I'm going to go back and look at the Muni Court record to see if it's there? Am I remember that correctly?
Yes, Your Honor, the trial court or the trial magistrate did ask when was the key returned. The responses were that, the response from plaintiff's counsel was that it was returned finally on February 10th, 2022. And the trial court did indicate that it would take judicial notice of this entry from the municipal court. However, when you look at that record within the docket, that entry from the municipal court, it does not indicate or state what the defendant's remedy was as a result of his denial of plaintiff's writ in this matter.
Was an objection made to the court taking judicial notice of the Muni Court documents?
No, Your Honor, there was no objection.
In the document you're referring to would have been the ruling on the, I'll call it the first eviction that would file the eviction from August of 21 to roughly January 22. That's the document you're referring to, the court would have looked at to see when there was language about the keys being exchanged?
Yes, Your Honor.
And there was no hearing transcript from the Muni Court available at that point in time?
There should have been, Your Honor. It was not within the docket that I saw.
Okay.
So, you have plaintiff who testified at trial that it provided the defendant's counsel with the key, and there was nothing more. Then you have plaintiff's counsel referring or making statements about when a key was provided to the defendant. Plaintiff's counsel stated September 2022 the first time, and then next plaintiff's counsel stated September 2021, and then it was October 2021, and then they settled on February 10th, 2022. However, statements by the attorney are not considered evidence to be considered by the court when rendering its decision per State v. Dickey, 2023, Ohio 705. And so, that would mean that the trial court, the only evidence, again, before the trial court was plaintiff's statement that it returned a key, nothing more. So the issue is, where did the court get the date of March 2022 as the date to begin, that back rents began to accrue for the plaintiff? There's only two conclusions that can be drawn about where this came from, and that is plaintiff's counsel's statements and plaintiff's counsel's affidavit, which was submitted post-trial. And it was submitted along with plaintiff's trial brief, and the issue there is the trial court did not ask the parties to brief or establish in its post-trial brief when a key was returned. Again, that was plaintiff's burden at trial, and with the evidence submitted, which was one statement or one sentence, that was insufficient to establish that a key had been returned and whenever for the back rents to begin to accrue in March 2022. Nevertheless, the trial court found that the plaintiff was entitled to back rents beginning March 2022 through December 2022. In essence, the trial court lowered the plaintiff's already low standard finding that it met a burden that it had not actually met based on a reading of the record and the transcripts within the record. And in sum, appellant prays that this court would overrule that judgment and remand the matter for further proceedings. Thank you.
Thank you. You have the remainder of your time for rebuttal.
May it please the court, my name is Janann Wickham, and I represent the plaintiff appellee, ProAmerica Real Estate, LLC. There are multiple standards of error raised by Copley Tire in its appeal, but there are also multiple issues for Copley Tire, where this court should find Copley Tire's arguments not well taken at the outset. To address these issues in the most efficient way, we have to look at them in multiple buckets. First, forfeiture. Second, failure to develop plain error. And third, the analysis of the remaining assignments of error under the applicable standards of error. So although appellant only addressed the first assignment of error, I will still nevertheless go through all of them. Starting with forfeiture. The bench trial here was held before Judge Reinbold, who was sitting by assignment as a magistrate, which required Copley Tire to object to any issues as to the magistrate's decision, and therefore the magistrate's actions, before the trial court, or else those issues were forfeited for appeal. Copley Tire filed objections to the magistrate's decision, and therefore those objections identify the extent to which Copley Tire can now raise error, because any error raised on appeal must be as to the actions of the trial court when considering the objections.
So I get to me, the case does boil down to these objections,
Yes.
and we're saying they're very general. Are they a sentence long? I haven't looked at the document. They don't flesh out the argument completely, or how general are these objections?
Well, so there were, I believe, 5 different objections that were raised before the trial court, and they had some headings and then the argument beneath them.
So there were some paragraphs of argument for each objection?
Yes,
But it was
however,
just too general for the judge?
so the first one, when Copley Tire argued that the trial court or the magistrate erred in awarding these 10 months of back rent, they said, well, it's because there were unclean hands. And then it cited to statements made by the defendant's representative, and that was it. So
The judge never, the Judge Reinbold, the acting magistrate, we'll call him in this particular case, never ruled on the question of unclean hands, did he?
he did not explicitly rule on unclean hands, but implicitly he did
How,
not.
if he doesn't rule on that, how do you make anything other than a general objection? How do you say, let me point to finding this fact 7, 8, 9? Because you can't, because he never made a specific objection.
So he made 17 specific findings of fact and 8 specific conclusions of law. And the findings of fact that he went through the history, essentially, of what happened in the case and what he found to be what happened in the case, and then his conclusions based off of that. But even if it was somewhat general, or if he didn't explicitly overrule the unclean hands argument, the trial judge still conducted a de novo independent
She
review.
never discusses unclean hands as well.
She
She
does
just
not.
said, I did an independent review. She never talked about unclean hands. She said, well, you made a, sorry, but you made a general objection, not specific, you lose. And she never rules on the unclean hand question.
She did not explicitly rule on the unclean hands objections. However, like motions that are filed, if the court does not explicitly rule on a motion, it's considered deemed to be denied.
So your view would be if a defense is raised and there's a trial and the court doesn't rule on the applicability of that defense, they must have implicitly overruled it without any language in their order.
Yes. However, when it's applied to the facts of this case, there were multiple issues where there was forfeiture before the Court of Appeals, not the Court of Appeals, forfeiture, At this stage, because the objections were not raised before the trial
What
court,
of the 5 assignments of error do you believe specifically are forfeiture questions?
the first and the fifth have both been forfeited because those are issues that are raised for the first time on appeal. And it's something that Copley Tire recognized because they raised a plain error argument in the headings of the first and the fifth assignments of error, and also in the fourth assignment of error, but that's kind of an additional separate issue because there were objections that were raised related to the fourth assignment of error where you can get to the standards of error. But as far as the plain error goes, those arguments were not developed in Copley Tire's briefing. And so this court has held that if an argument is not developed, then the court's not going to make the argument for the party. And plain error is a heavy burden. The Ohio Supreme Court has emphasized that it must be strictly limited to extremely rare cases.
But whether the argument was developed or not, isn't that sometimes in the eye of the beholder? In terms of the law, like if there's a paragraph about it and it generally references parts of the trial, is that raised well enough or not?
Well, in this case, the application of the plain error standard is completely missing in Copley Tire's brief.
You're talking about just for the certain assignments of error, where they weren't raised at all? I mean, not even in passing.
So the standard of error was addressed and it was defined, and then it was basically never mentioned again. So,
And that's 1 and 5, you've indicated that assignments of error 1 and 5 are subject to that forfeiture, plain error, not argued analysis.
right, and therefore 1 and 5 should be overruled outright because they were forfeited and the plain error assignment was not fully developed. So it was Copley Tire's responsibility to show how this should be one of those extremely rare cases where this should apply. And so without assignments of error 1 and 5, and then plain error also wasn't developed under assignment of error number 4, so it doesn't need to be considered there.
Well, they alleged that it was plain error in their assignment.
In the
It seems in reviewing the record before the trial court, it seemed that argument was made before the magistrate and before it was part of the objection to the trial court judge. That question of the $1,300 in trash. It seemed to me they objected to the trial court on that issue.
Yes, that
Are they
one.
making a different argument now on appeal than they made before the trial court, or is it the same argument before the trial court?
So in part, there's a new argument that was raised, and then in other part,
And
it's
what
the
would you
same.
say is the new argument raised on appeal?
The new argument raised on appeal, I would say, is the allegations regarding receipts or actual cost for the trash removal and the rat remediation. So those are the new things which also would have been forfeited on appeal.
That is on issue number 4 for the 1,300, or that on issue number 5?
That's on assignment of error number 4.
Okay. All right, thank you.
Yes. So then the issue here for assignment of error number 4, and then I'll go back to 2 and 3, is whether the trial court's decision overruling Copley's objection, which claimed that there wasn't a link between Copley Tire and the trash and the rat infestation, was an abuse of discretion or against the manifest weight of the evidence. And so under common law, a commercial tenant must return a leased premises in substantially the same condition as when it was first received, minor wear or reasonable wear and tear accepted. So here, Copley Tire only cited to one case to attempt to support its position, which is distinguishable because it dealt with a residence and reasonable wear and tear. So while it is a general proposition that a landlord must present evidence of the condition of the premises before and after the tenancy, it's not always fatal to not do so. And that's particularly true here because Copley Tire's tenancy began several years prior to ProAmerica becoming the landlord. So it actually went back 2 prior landlords before ProAmerica. And the damages at issue here, which included trash from the abandoned tires and a rat infestation could not be considered wear and tear on the premises, particularly when Copley Tire was permitted back into the premises beginning in February of 2022, and the abandoned tires pursuant to the court's December 14th, 2022 order. So after the expiration of time for Copley Tire to remove its items, that's when ProAmerica went in to remove all the tires, and that's when it found the trash from the tires and the rat infestation.
Does Copley Tire, in presenting their claim that they sued because letting your client to store their properties, things of that nature, did they, in doing that, in essence, allege that they had left property or agree they had left property on the premises that had to be removed by your clients?
So they did agree because they said that Copley Tire never went back in after they had been essentially excluded from the premises. So all of those tires, pursuant to the trial court's December 14th, 2022 order, anything that was left in there was considered abandoned, which ProAmerica then had to clean out. So under these circumstances, Copley Tire has not shown how the trial court's decision in overruling its objection was unreasonable, arbitrary, or unconscionable, and nor did Copley Tire make any argument under a manifest weight of the evidence standard of error. There was no analysis or assertion that this should be an exceptional case where the evidence weighs heavily in Copley Tire's favor to warrant reversal, and as such, the fourth assignment of error should be overruled. To go back then to the second and third assignments of error, both of those deal with that 10-month of unpaid rent time period. So under the second, Copley Tire claims that the trial court erred in finding its objection general rather than specific. And in support of its second assignment of error, Copley Tire did not cite to any case law to claim that its original objection met the specificity requirement under Civil Rule 53D3B. Under this court's decision in Niederst versus Niederst, Copley Tire's original objection was not specific because it failed to object to a specific finding or conclusion of law, even if it was one that implicitly overruled the unclean hands argument, particularly because both that case and this one only cited to general law and made statements without any application. For this reason alone, there was no error on the part of the trial court, and Copley Tire's second assignment of error should be overruled. Additionally, an abuse of discretion requires the trial court's ruling to be unreasonable, arbitrary, or unconscionable to warrant reversal. And again, Copley Tire did not make any application of the standard of error to its second assignment of error. And the words unreasonable, arbitrary, and unconscionable are completely missing in its analysis of that assignment of error. But even assuming that there was an abuse of discretion and finding the objection was not specific, the error was harmless and it should be disregarded because the trial court did that de novo independent review. And that included the trial transcript, it included all of the evidence, and it included all of the exhibits. And it still found the magistrate's findings of fact and conclusions of law reasonable. The third assignment of error focuses upon the unclean hands doctrine, but Copley Tire tends to conflate the actions of the magistrate with the actions of the trial court in finding that liability. So the question is really whether the trial court's judgment overruling Copley Tire's objection as to the unclean hands doctrine and finding the magistrate's findings of fact and conclusions of law reasonable was an abuse of discretion. So, for the unclean hands doctrine to apply, the conduct must have been reprehensible, grossly inequitable, or unconscionable, and not just negligence, ignorance, or inappropriateness. And it also should not be applied when the party has legal remedies to address the alleged misconduct. So the single case that Copley Tire cited does not support the claim that ProAmerica engaged in reprehensible, grossly inequitable, or unconscionable conduct because it dealt with prohibition against self-help for a residential premises. So the Ohio legislature has not found in cases of commercial tenancy that self-help is against public policy. And so even if there was a mistake in orally terminating the tenancy and excluding Copley Tire from the premises, this doesn't show how that rises to grossly inequitable, unconscionable, or...
And you're running low on your time, and I
Yes.
have a question, so let me ask you that. I appreciate everything you're saying about the law and the fact of uncleanness. How, as a reviewing court, am I supposed to know if the trial court, the magistrate, ever considered uncleanness in this case? Didn't talk about the law you're citing, didn't talk about any of the facts you're talking about at all, and didn't discuss unclean things. How am I supposed to know the trial court actually considered that, the magistrate considered that?
Based upon the findings of fact that the magistrate went through in his determination of when the key was returned, the fact that the key was returned, and the fact that Copley Tire had the opportunity to go back into the premises, there is that implicit understanding that the unclean hands doctrine was implicitly.
I mean, we don't say that implicitly, clearly the court
Right.
did explicitly rule.
Right.
And the magistrate, and the trial court never explicitly ruled on it well. That seemed to be tucked under the category of, I think that's a general, not specific objection, and never talked about unclean hands. Is that fair from the trial court judge's review of the objection?
That
That unclean hands objection was the objection the trial court was finding was a general objection and not a specific one. The trial court never specifically addressed the question of unclean hands.
I would say that the trial court did still address it just by saying that they went through that independent review.
Just
and then-
your view would be just the independent review was enough for us to consider that to be sufficient.
Yes, but even if you don't consider it to be sufficient, even looking at what the law is for the unclean hands argument, Copley Tire's assignment of error would still fail.
You are out of time. You may please briefly conclude.
So with that, Copley Tire has failed under each of its assignments of error, and ProAmerica respectfully requests that this court affirm the trial court's judgment entry, which overruled Copley Tire's objections and adopted the December 11th, 2023 magistrate's decision. Thank you.
I'll start with the assertion that Copley Tire did not give an analysis under the plain error standard. Of course, appellant will disagree with appellant's interpretation of its brief and its argument under its assignment of error 1. Within the appellant's brief, it raised Bressie v. Thomas, and within that record or case, this court identifies 3 factors that would enable a matter to be reviewed under the plain error standard. The first is that an error occurred. Appellant asserts that an error did occur, but the trial court relied on evidence that was not presented during trial. Second, that the error was obvious. Appellant asserts that the error was obvious and could have been ascertained by a reading of the record and even just the transcripts themselves. And third, that the error affected the outcome of the proceedings. Appellant asserts that there would not have been a judgment against it, and particularly regarding back rents, if the court had found or considered or concluded that the plaintiff did not meet its burden, which the evidence support that the plaintiff did not meet its burden to establish by preponderance when a key was returned to the defendant. And therefore, appellant is asking that the court overrule this judgment under that basis. The plaintiff asserted that this court should sustain the judgment as it relates to appellant's argument regarding its error or objection to the trial court's decision that its objections to the back rents were general and not specific. The trial court, there were specific assignments of error, there were specific facts, and then there were specific conclusions of law. The conclusion of law at issue is that the defendant was liable or to be responsible for paying the plaintiff for back rents beginning in March 2022. Plaintiff's objection specifically raised the issue, or it specifically objected to this finding, and appellant argues that this is a specific objection to a specific conclusion posed or rendered by the trial court. Next, plaintiff asserts that appellant failed to establish how the appellee's conduct was reprehensible to fall within the unclean hands doctrine. Well, the facts as posed in the appellant's brief establish that the appellee had locked it out of the space that it was renting. And appellant was locked out from August 2021 until a time that is not clear from the record and from plaintiff's testimony presented at trial. Nevertheless, that, and also the appellee had no basis to support its decision for locking the appellant out of the property. This in itself is reprehensible conduct that should be considered or applicable and analyzed under the unclean hands doctrine.
You have about a minute left, Councilman, your time.
Appellant asserts again that the judgment issued by the trial court is fundamentally flawed and asks that this court would overrule the judgment and remand the matter for further proceedings. Thank you.
Thank you. And on behalf of the court, thank both of you for your presentations this morning.
Thank you.
The court will take the matter under advisement and issue a decision in due course. When that decision is released, it will be mailed to you by the clerk of court and also be available on the highest Supreme Court website. With that, the court is now adjourned until Thursday, November 7th.